Why don't you give us a really quick background on the lawsuits?
So Camp Lejeune became the law about a year and a half ago. There's a 2-year window that will go till August of this year to file new claim forms. The law is relatively short. There are so many legal questions about what this law means. And that took us a long time to get going because the government did not respond to any of these claim forms for a long time. It was about a year before things started to happen, but things have really picked up pace over the last 4 or 5 months. The most notable of which is the first 100 cases, they're called track 1 discovery cases. So 100 cases out of thousands of potential cases are going to have discovery done, and we have one of those cases. It's only a small group of law firms in the whole United States, and we're doing depositions and both sides are turning over documents regarding those first tier 1, track 1 cases. So that's ongoing. When you start having things happen in court, it brings up a bunch of other issues. What's going to happen with estates? What's going to be required as far as document production? And there's a really big question about whether or not there's going to be jury trials. We're going to get to that in a second.
Okay, but let's start with the basics. For those who are affected by the Camp Lejeune water contamination, what are the first steps?
The first steps is really talking to a lawyer. You can go pro se. I wouldn't recommend it. We're dealing with this every day. There's hundreds of legal issues, and it's a challenge for all the lawyers involved. I can't imagine that a pro se plaintiff is going to be as effective as a lawyer. So I think it really starts by talking to a law firm, and you have a choice of really big law firms or smaller law firms and plenty of good lawyers. We're working with a bunch of lawyers as part of the Track 1 discovery. There's good lawyers. Hopefully we're one of those good lawyers.
And what about the administrative claims with the department?
What happens in a Camp Lejeune claim is, first, we have to prove 2 things. Exposure during the window from 1953 to 1987. Can we prove exposure? Do you have an illness that may be related to toxic exposure? And there's a whole bunch of them, including various cancers. So that's what we're looking at first. If we think that you may have a claim, step 1 is filing an administrative claim form with the Department of the Navy. They have 6 months to respond. Generally, they have not been responding. And then at that point, you can now file a short form complaint in the Eastern District of North Carolina.
With so many administrative claims filed, what is the Navy's response?
Yeah, the Navy has not responded, as far as I know, to any administrative claim forms. We have filed hundreds of administrative claim forms at this law firm. They responded early on to about 10 or 11 claim forms, and they haven't responded really to any since then. The judges keep asking them about it, and they say they're going to get around to it, and they don't.
So if an administrative claim goes unresolved, what happens?
They have 180 days to respond. If they don't respond within 180 days, 6 months, then it's deemed denied and we can proceed with the cases, which is generally what's happening right now.
And let's talk about the deadline.
August 10th, 2024 is a hard stop deadline, and you have to have your claim form in before then. You can't wait until August 8th to come to us because we need to see the medical records and we need to see the military records. So we are fast approaching this deadline. It's taking us about 6 months to get military records. Maybe that's down to 4 months now. There were thousands and thousands of people requesting their military records because of this case and the earplug cases through 3M. So there's been a lot of demand because of lawsuits for military records, and we need time to work your claim up. So if you think you were there or a family member was there, now is the time to do something.
Time is of the essence.
Truly is.
So how many cases have been filed?
There have been about 2,000 lawsuits filed to date, but there have been 175,000 claim forms filed. Almost half of those are people who are deceased, and there's been some real questions about how estates are created. There's a thing in North Carolina called an ancillary estate. Just last week, the court said you don't have to open an ancillary estate in North Carolina, so that's going to save a lot of law firms a lot of work, and that was a reason to slow down the filing of those claims, and then we'll see what happens with the other. I'm surprised there's not more cases filed. We have not filed all of our cases for various reasons. There's, of course, hopes of settlement at some point, and there's a whole bunch of effort going into these original about 1,500 or so lawsuits were filed before November, and that's the track 1 early on cases. And then the track 2 cases were just announced last week also. So there is a lot going on as far as developing the cases. We call them bellwether trials. Some people would call them like a test trial. That's how we're going to establish what potential settlement values in the Camp Lejeune cases might be.
So there will be trials.
I think there will be trial, absolutely.
Explain to me a little bit about what the bellwether trial is.
Think of it like a test trial or a first trial, and ideally it's a representative case. It's a case that's kind of the average case from the plaintiff and the defense side, so that both sides learn a lot about what might happen if you try hundreds of other cases and what a jury might do and what issues may come up, and you get some rulings from judge on particular issues, how expert witnesses are going to testify, things like that. And the idea is to use bellwether trials so that everyone can learn about their cases and hopefully lead to the resolution going forward.
So what are some of the diseases that are being used or included in some of these beginning trials?
Yeah, so we expect that there will actually be 3 tracks, track 1, track 2, and track 3. There are certain injuries that are very, very closely associated scientifically with toxic exposure: bladder cancer, kidney cancer, leukemia, Parkinson's disease, and non-Hodgkin's lymphoma. There's a whole bunch of other diseases that we believe are also. Those are largely accepted by science, and I think may be generally accepted by the government. There will be a question about where the line is drawn. That's probably going to be track 2 or track 3 cases. So that's your track 1 cases.
Can you tell us about some of our cases that have been selected for these trials?
Yeah, so track 1, there was 100 cases selected. One of our cases was selected. It's a non-Hodgkin's lymphoma case, and it's been a really interesting process to be part of that. So you have 100 plaintiffs, and really we all want to work together for very basic reasons as how is the defense going to read our documents? How are those documents going to be produced in a timely manner? So all the lawyers have to come together and say, how are we going to stamp the documents, the numbers on the documents? How are we going to schedule these 100 depositions so that the government can ask questions in a timely manner and we can move the cases towards a trial? So it's been very interesting and a lot of fun to work with all the lawyers from all around the United States.
So what's this about the court making a decision to not allow jury trials?
The government has made a motion to strike the request for jury trials. I think the language of the law is pretty clear that most people want a jury trial and they should be able to have a jury trial if they want one. The court said, no, you're not entitled to a jury trial. They granted the government's request. So the lawyers are appealing that decision, but in the meantime, we're continuing to work towards trials, whether the trials will be trial by jury or bench trials, trial by judge is an open question right now, but the original request to strike the jury trials was granted.
And for lawsuits on behalf of ones who have passed away, does an estate need to be established?
Correct. And that answer just kind of came out last week, what that estate would look like. So one of the confusing things is you have 50 different rules of estates in 50 different states, plus DC and Puerto Rico and all these things. So everyone is getting an estate set up in their home state.
All right, so we've heard about an elective option. Can you give us an explanation of what that is?
Yeah, an elective option is apparently the government are going to make some settlement offers. We have not received any elective options in our hundreds of cases that we have. It looks like perhaps we're trying to go from the press releases from the government. They haven't made any formal offers to us. Do we have cases that would qualify that may be in some people's best interest? Yes, we're looking at maybe 1% to 3% of the cases. The requirements generally are you have to have what we would call a tier 1 disease. Only certain illnesses qualify, and you have to have kind of a shorter latency period between the exposure and the diagnosis for the illness. That's where most people actually don't qualify. They don't get diagnosed till after the latency period requirement is over. So right now it looks like a couple dozen cases out of 100,000 or more have been settled that way. It's not something that has been a major development that they purport it to be, at least so far. I think it could be important because it shows the framework of how a potential global settlement would resolve all of the cases.
So what's the anticipated timeline?
I think the anticipated timeline in any major case is 3 to 5 years. We're dealing with the government here, so my guess is it may be a little slower. We're almost 2 years into this right now. We don't have a trial date scheduled. I think there has to be a trial before all these cases resolved. There's a lot of issues. I think we are looking for a trial hopefully this year. Is that going to happen? We don't have a trial date. So I think it's possible, but not guaranteed. And then once you have some trials, I think that will push potential settlement, but we're not there yet.
So for anyone who is maybe on the fence about even reaching out to someone, what's your advice?
I would talk to some lawyers. I think we can educate you. But most of the people that we're talking to now are very educated. They've done a tremendous amount of research. We're happy to talk to people, but there are people working on this every single day who can answer your questions. Hopefully we've answered some of them here.
And where can they find us?
Yep, King Law on the website, and under Camp Lejeune, there's information there. We try to post the updates as they come in. This is really a compilation of our last couple months of updates, and there are going to be more updates. You can certainly subscribe here. We'll keep putting out updates as they come along.